In this video, we're going to be talking about the third of our three certainties, and that is certainty of objects. And we've already looked at the other two in previous videos, namely certainty of intention and certainty of subject matter. So if you haven't seen those videos already, I'd recommend you go check them out because they all lead nicely into this third certainty video. So again, the underlying principle is that a trust must be enforceable and there must be someone who can bring an action to enforce the trust. If there's no one who can enforce a trust, the trust will fail for uncertainty of objects, unless it is a charitable trust, in which case the Attorney General can bring an action. So a trust will be void if the objects of that trust, meaning the beneficiaries of that trust, are uncertain. The principle dealing with certainty of objects relates to the needs for the trustees to be able to know the identity of the beneficiaries under a trust, because in turn the court cannot know whether or not trustees have exercised their powers properly if there is uncertainty as to the people who stood to benefit from that trust. Thus, it is said that it is important that the court have someone in whose favour they can decree performance of the trust, and we can see that from the Morris and Bishop of Durham case, and that the identity of the beneficiaries must be certain so that the court can police the performance of the trustees properly. Now, if there was some dispute as to the manner in which the trustee should deal with the trust property, then the court would need to be able to take control of the management of the trust. But it cannot do this if there is some uncertainty as to the identity of the beneficiaries. Consequently, any trust which is uncertain as to its beneficiaries will be void. And we have this quote from the Morris and Bishop of Durham case: "There can be no trust over the exercise of which the court will not assume a control, for an uncontrollable power of disposition would be ownership and not trust. There must be somebody in whose favour the court can decree performance." So that's just saying that there must be certainty of objects. The proprietary rights of beneficiaries. So by the principle established in Saunders and Vautier, in the case of a bare trust or fixed trust, the beneficiaries acting together can direct the trustees to transfer the trust property to them. This means that they have the proprietary rights as opposed to the rights in personam against the trustee. So beneficiaries own the property in equity. They have the rights to ownership and they can direct the trustees to vest the property in them should they choose to, and if they act together to do so. This is something that you should already know from the early stages in the trust course or in my early videos where I discuss it in more depth. Where a trust is discretionary and exhaustive, for example where the trustees have to use all of the trust property for the benefit of a fixed class of individuals, so in other words, an exhaustive discretionary trust is a trust where trustees must allocate all the property and cannot retain any of it. So in circumstances where a trust is discretionary and exhaustive, then those individuals, if all of them act together, may invoke the Saunders and Vautier principle. And from this case of Rees-Smith, the case said that, the judge in this case said that in those circumstances, it appears to me, notwithstanding the discretion which is reposed to in the trustees, under which discretion they could select one or more of the people I have mentioned as recipients of the income, and might apply part of the capital for the benefit of Mrs. Aspinall, and so take it away from the children, that the four of them, if they were all living, could come to the court and say to the trustees, hand over the fund to us. So if there is an exhaustive discretionary trust of which there are three beneficiaries, it will be for the trustee to decide how the trust property is to be divided, exercising their discretion. However, under the principle of Saunders and Vautier, the beneficiaries can override the discretionary power of the trustee. Therefore, the property would be given to the beneficiaries for them to decide how the property should be divided. So this quote here from Rees-Smith just says that if all the beneficiaries are over 18 and sui juris, then they can dissolve the discretionary trust and decide the division of property themselves. So the identification of beneficiaries. Now, usually this is not an issue, and it is pretty clear who the beneficiaries are going to be. Trust documents tend to say exactly who the property is meant to go to. But the beneficiaries of a trust where this isn't so clear may be identified in 4 ways, or just in general, the beneficiaries of a trust may be identified in 4 ways. So named individuals, for example, it could say my wife Jill, my husband Jack, for example. Secondly, a group defined by description, so my children would be a sort of group of beneficiaries. Students enrolled at the University of Oxford would be a group defined by a description. And thirdly, some organisation or association, so like the Oxford Angling Society or the Oxford Law Society. And finally, a general class of people. So we've got young people and residents of Oxford. And we're going to look at these 4 particular cases in a bit more depth. I'm going to quickly identify 2 points about these lists, about this identification of beneficiaries, before in the next video we're going to go into a bit more depth talking about particular trusts. Now, the first of these, so the named individuals, would form a valid private trust, and the fourth of this list, a general class of people, would only take effect as a charitable trust. So if the trust named individuals, that's our first identification of beneficiaries, our first on the list, then there is no issue. A valid private trust will take effect. So if I say this trust is for my wife Jill, then that is a valid trust, that is a valid private trust that will take effect. The objects of this trust are very clear. Okay. The fourth one of this list, so that's a general class of people like young people or residents of Oxford, would only take effect as a charitable trust for the benefit of the public or section thereof. So even though the beneficiaries aren't exactly clear in the fourth one, it would be possible to create a trust as a charitable trust. And this is something that we're going to look at completely separately in another video when I talk about charitable trusts. But this is really where charitable trusts, what the object is of a charitable trust is a general class of people. Okay. Now the second class, where the beneficiaries are identified by a description, and the third, where the beneficiaries is an organisation or association, are where the requirements of certainty of objects may cause a particular issue. Okay, so these are the ones that we mostly need to focus on. So the named individuals, like my wife Jill, that's fine. The objects are certain. The fourth class of individuals, so a general class of people, that's going to be a discussion for charitable or charities, charitable trusts, and that's also fine, a separate sort of remit that we can deal with later. So it's really these 2 middle groups that we need to be dealing with. There are lots of difficulties with upholding a trust where the beneficiaries fall under the second one, so a group defined by a description, and the third one, an organisation or association. In other words, how can we tell exactly who makes up students enrolled at the University of Oxford? If someone withdrew from Oxford University last week, but had not been taken off the university books, are they a member of the university, of the class, and therefore entitled as a beneficiary or not? These are the sort of questions that sort of crop up time and time again when we deal with these sort of middle 2 types of beneficiaries. Now, the test to be applied to determine certainty of objects depends upon the nature of the trust. So with a fixed trust, it is and always has been that a trust is void unless it is possible to ascertain every beneficiary. And with a discretionary trust, the House of Lords decided in MacPhail and Dalton that the test was, can it be said with certainty that any individual is or is not a member of the class? Now, these particular different types of tests, depending on whether we have a fixed trust or a discretionary trust, is something I'm going to dive into in the next video, because I feel like that requires a video of itself so that we can get really quite deep into it so we understand it, because some people do find this sort of distinction and these tests a little bit tricky first time round. So I'm going to leave this video here, and in the next video we're going to be talking about those fixed and discretionary trusts with regards to certainty of objects, and looking at the McPhail-Dalton case, for example, before moving on to a discussion about powers, etc. So if you have any questions about this video, please leave a comment below and I'll get straight back to you. And don't forget to like this video and subscribe to my channel. Thank you very much for watching.